I'm Ed Pantiliat with Hymson Goldstein Pantiliat. I've been practicing law for over 16 years now. I've settled millions of dollars of personal injury cases. The insurance company hires well-trained professionals to make sure that they do their best for the insurance company's bottom line. If you're not a trained professional, it's best that you hire a lawyer to handle your claim. At Hymson Goldstein Pantiliat, we only get paid if you do, and our business is your peace of mind. Thank you. The odds are that at some point you may get into a car accident. And chances are as well that you may be injured in that car accident. Not all of us are trained professionals in what to do if that situation were to occur. So I wanted to share with you a few tips in case you are in an accident. First, don't move your car until the police arrive. The reason being is that the police want to do a full investigation, and sometimes they draw a diagram of exactly what took place. If you've already moved your car before they arrive, then they have to sort of manipulate the situation as opposed to seeing the cars exactly what they were, where they were at the time of the accident. Secondly, and that is, try to stay in your car until the police arrive. If you get out of the car, have conversations with other people, it may be misinterpreted. People always think that they know what they're saying when they're saying it, but in a time of an accident, most people are not thinking straight. Stay in your car until the police arrive and try only to speak to them. Try not to talk to the other driver. If they come up to you, then you can exchange some information, but try to limit the conversation to that. If you're injured, be sure to tell the police that you are. There's a specific place in the police report where they mark if people are injured. If you say that you're not, they'll mark that you are not injured. And if you subsequently pursue an injury because you are injured, then the police report will be used against you. So if you are injured at all, tell the police. If they ask if you want medical attention, if you feel that you need it, of course ask for it. If not, say to them that you are injured, but you'll take care of it on your own. If that's the case, then when you get home, or right after the accident, as soon as possible, try to call your doctor. Get an appointment as early as possible. If you are injured, then it's important for you to get examined and treated. If for some reason you can't get into a doctor right away, then maybe call another doctor who can be referred to you from either a lawyer, a friend, or a colleague who can see you in a short period of time. This would also help expedite your claim. You also want to call your insurance company, even if you're not at fault. Let them know that you're in a car accident. It could be that the other insurance company is a little late in getting all their information and you may not have your vehicle. Maybe you have rental car coverage on your own vehicle. You can use that, and then your insurance company can get reimbursed from the other carrier. Let them know in any event, even if the person says that they have insurance, sometimes their insurance may have expired and you don't know that. So let your insurance company know. Sometimes if there's a significant delay before you inform them of a car accident, they can deny coverage completely. At some point in time, if the other driver is insured, you'll be contacted by his or her insurance company. They're going to want to know exactly what took place. Try to tell them just the facts of the accident. If they ask if you're injured, you can let them know that you are, but basically let them know that you're in treatment. The reason that is because if you feel that you only injured your neck or your back, and then subsequently you had a knee injury and didn't tell them that at the time of the recorded statement, then they can say that maybe it didn't happen at the time of the accident. So try to minimize the amount of injuries that you discuss with them, if you discuss any injuries with them at all. Also, if you have any medications and come out of pocket and incur expenses on your own that are not covered by your insurance plan or what have you, or co-pays, keep all your receipts. These are all reimbursable to you as well in any personal injury accident. Keep them in a shoebox until the time is right to settle your claim. Also, if you've missed any time from work, keep a record of that. If you have pay stubs before the accident, keep those pay stubs. If you've missed time subsequent to the accident, keep those pay stubs as well, because they'll show the difference between what you made before and after the accident. If you're self-employed, it's very important to make sure you keep a journal. If you have a calendar and you're missing appointments that causes you to lose revenue, make sure you keep track of that information as well. I think.
Hello, I'm Irving Hymson, and I wanted to talk with you today about some of the ways that people use a law firm, such as ours. Lawyers are not only for people involved in controversy or the wealthy. This is a complicated world in which we live, and people need advice and input from a variety of people to help us get through the conditions of life. We have doctors, we have car mechanics, we have insurance agents, car buyers, tax advisors, good computer gurus, all necessary parts of our team of people that we draw upon to help us deal with the things that are important in life. Most important part of your team is your lawyer, who can help you make informed decisions, save you money through negotiation, has street smarts, talk to you about tax planning, guarding against liabilities and other dangers, fraud, and the like. And most of all, a lawyer provides you the comfort of knowing that you and your family are well represented in a world that is often unpredictable and hard to understand. I talk about legal preventive maintenance for the individual, for the family, and for the business. I think of it as a semi-annual checkup that people may want to look to. You can find a punch list of these things on our website under the articles frame, and download whatever you need from it. And I'll be talking from that checklist today. You can also find out more about me and the members of the firm by looking at our biographies on the firm website. And as well, please take the time to look at the testimonials that we have posted there from our clients. I think it's important, not only the knowledge base of the attorney that you may choose to work with you, but also the nature and the character of that person and what people think about that individual. I'm a transactional lawyer, a real estate certified specialist by the Arizona State Bar, a hard-won designation, and also a business and contracts lawyer. These days, I'm spending an awful lot of my time with people who are wondering what do they do about their real estate homes or investments that are underwater. And how do I deal with it? What does a short sale mean? How does anti-deficiency statutes relate to that? And what's my best options given the economic conditions that I find myself in and then the marketplace finds themselves in? I would say I'm doing 5 to 10 consults with people about that on a weekly basis. You know, for the most part, one's home is their biggest asset that they purchase in life, whether you're buying or selling. And understanding your rights, obligations, and options when it comes to that large asset is a very important feature. A lawyer can be very cost-effective in helping you work through that. There seems to be a myth with people in Arizona that when you come here you don't need to use a lawyer in that process, but I can assure you that that's not an informed decision. And these days, so many people are finding now that they are in distress that they wish they had made that decision to consult with an attorney while buying or selling their homes. The title policy would be something people need to know the nature of title. The fact that you buy a home and the title company gives you a title commitment, it doesn't mean that no one has passed upon the adequacy of the state of title, and an attorney can certainly help you with that, as well as with leasing. Today we're seeing a lot more of the creative financing techniques that were employed 20 years ago when we had our last downturn in the market, where people are finding that in order to move their properties or to get into properties, and if their credit is not what it might be, or their ability to secure a loan is not what they hoped it would be, that creative financing techniques are needed, such as lease purchases, lease purchase options, seller carrybacks, wrap loans, assumptions, taking property subject to existing obligations, and finding ways to be creative to get the job done. People also are more interested these days in estate planning. I think we are at a time when people are looking to do more planning about what is going on in their life, rather than relying on the fact that we're in a place which is sunny every day and the economy is rising every day. And in a rising economy, when good times, people don't look behind them too often because everything's moving forward, everybody's making money, everybody's fat and happy. Well, in times like these, people say, wait a minute, I need to do some more concerted planning, and are seeing financial planners and the like. They're also doing estate planning, looking to their wills and their trusts to make sure that they've taken advantage of the tax laws, that they've minimized probate opportunities if in fact that's warranted. For example, if people have properties in multiple states. Intestate succession is something that the law says that we will tell how your money and wealth will go unless you specify it in your will. In multiple marriage families, families where there's been prior marriages, this could be proved to be a problem. As people have vested rights under the statute, the way the law thinks it should go, not necessarily the way the person who would make a will would dictate how those assets would go. And then, of course, the will or trust provides an opportunity for specific bequests being made, such as who gets great-grandma's candlesticks, your memorabilia collection, the dog or the cat. Who best is suited to manage the money that you will be leaving? Sometimes that is not the person that is the best person to be the guardian for your minor children. And arrangements need to be made to make sure that the funds will be administered properly by the person that you think is best able to do that, and that your children will be left in the care of persons who you think are best able to do that, and sometimes they are not the same person. Personal representative is appointed to determine who is the one who winds up your affairs when you die. And then arrangements need to be made, particularly for couples, with regard to what happens if there's a common disaster. You're both on an airplane together, and both people die within a time frame that could involve actually winding up with two estates rather than one. And arrangements can be made to avoid that expense and difficulty. And then, of course, life insurance payees under your policies can be coordinated with your will and your financial plan. With the wills consultation and package that we do, we also discuss other ancillary documents like the living will. Do you want to establish or disconnect life support? You must direct that in writing specifically the way law requires, otherwise it may not be honored. People go either way with that decision, but whichever way you choose should be duly recorded. Durable powers of attorney are also part of that package. If you are incapable, who will run your business affairs, write checks, deal with creditors, and things of that nature. I had a case a little while ago where the husband of an older couple, the husband was in a severe medical situation and was in a coma for a prolonged period of time, and he had handled all the financial matters for the family. And his wife, the family assets were well in excess of 7 figures, but his wife was never involved with that, not even on the checking accounts. And with him in a coma, there was no ability for her to access their money and to pay their bills without going into court and having her appointed as a guardian at a large time and cost expense, easily taken care of with a single document. Medical powers of attorney are also included, who makes your medical decisions if you're not able to do so. What if your children need medical care and you're out of town and they're minors? Have you made provision for the people who are caretaking while you're out of town or while you're out of the country to be able to have the authority to see to their medical attention? And then there are other powers of attorney that we could talk about to close real estate deals or handle specific assets. We're doing a lot of business formations. They're advisable. The limited liability is the name of the game. One who is in a business does not want to bet the ranch, bet all your assets on the business in terms of if something adverse develops and you're sued. Setting up an entity, a corporation, or a limited liability company or a limited liability partnership oftentimes can help insulate the business problems from personal problems. Fairly simple and fairly inexpensive to do, but necessary, certainly. People who are using their business as an alter ego of themselves as individuals can run into trouble finding that the business gets sued, and then of course the personal assets might be reachable as well. Tax liability, taking advantage of the tax advantages that the law allows in a business context. Partnership buy-sell agreements, very important. The time to make them is when the bloom is still on the rose, when the business is being created and started, and everybody is still talking and making decisions based upon the common good of the enterprise, and not leaving it till later when people may have different points of view or different interests in providing for such things as what happens if I want to leave the business, what happens if you want me to leave the business, what happens if someone dies or is disabled. or divorced. Employee issues come up in that context as well, and you want to protect yourself from a situation where those who wish to set you up for a fall can do so. Having non-compete or confidentiality clauses are extremely important. We see this all the time, that they're either not done or done poorly, and then someone who has grown up in a business can go out and cross the street and be a competitor of yours to your disadvantage. And if you're being asked to sign a non-compete or a confidentiality agreement, it's very important that you understand the nature of that context. I've seen many employees who are excellent at what they do, who would like to continue in that same business in another firm within the town, in our town, or another town in the state or outside the state, and may be prohibited from doing that because they signed a piece of paper that they really didn't fully understand or think through when they were presented with it by their employer. Family matters also come up. Gifts to minors. People oftentimes will be of a gift-giving intention, and you don't want to create taxable events by virtue of doing it. Parents giving down payments on houses comes up. I see oftentimes that parents will put their children on the deed with them, add them to a deed afterwards at a time when the property has a great value, and they've been made a gift at that point. And created perhaps a consequence that wasn't their intention. Prenuptial agreements are something that are certainly in vogue for young and old alike. It used to be that we did prenuptial agreements primarily for second marriages of wealthy gentlemen. Later on, it became something of much more popular with senior citizens who did not want to live outside of a marital environment, but at the same time wanted to make sure that their accumulated assets would find their way to their offspring and grandchildren, if that's the case, and wanted to make provision for that. And today we see a lot of women who are working in business, who are marrying later, who have built up a lot of wealth on their own part, and want to make sure that that there are some appropriate prenuptial arrangements with regard to the wealth they've accumulated. Child support is another area that is, I don't think there's any more important subject, and time is always of the essence in that element. And with child support and other matters involving domestic relations, whether they be divorce or separation agreements, are important. The essence of all of these things is to make sure that intentions are clearly expressed and written in a way that people cannot have challenged later on when other circumstances develop. Debt collection is another area that lawyers' attention is focused upon. Government benefits, helping you get government benefits and helping you through the maze of the government bureaucracy. And then general business and investment counsel. I'm practicing law for well over 40 years and have an ability to provide a perspective and wisdom and advice that is easily availed of just with a phone call. Finally, there's a lot of business buying and selling. People who are looking to retire expect to sell their businesses and derive the fruits of their labor. In this economy, it's a little harder to do because of the nature of the tight money. And so creative arrangements are often necessary and desirable to assure that that can happen perhaps over a period of time. If one is buying a business, there are any number of due diligence elements that one would have to be very careful to inspect so that you don't buy the proverbial pig in a poke. And the same is true with commercial real estate projects and commercial real estate ventures. Anyway, we look forward to serve you, and if you need any further information, you certainly know where to come. This is Irving Hymson, and I appreciate your time and attention in listening to this video. Thank you.
Hi, I'm David Goldstein. I'm one of the partners here at Hymson Goldstein Pantiliat, and we're going to talk a little bit about the services that we provide to people who are facing financial challenges. A lot of what we'll talk about deals with bankruptcy. And when we provide bankruptcy counseling to folks who are seeking relief under the Bankruptcy Code, we're a debt relief agency, as that term's defined in the statute. I've got to say these words because the law requires me to. These days, bankruptcy has become a bit more complicated for people who are considering taking advantage of the remedies that the law allows them. The framers of our Constitution, for very early on, required Congress to provide relief for debtors. For that, in England, they had to go to prison. But the law has evolved to allow people who have crushing debts to get relief from them and get a fresh start. And this is provided through the Bankruptcy Code. In 2005, Congress revamped the Bankruptcy Code substantially, and in some ways made it more difficult for people to get bankruptcy relief. After 2005, people had to pass what's called the means test. And this meant that their income had to be at a certain level in order to pass. Generally speaking, we look at the median levels under the United States Census Bureau for households of particular size. A household of one person has one level, household of two a higher level, household of three even a higher level. And if they're below the median, they pass the means test. But if their income is above that, not all hope is lost. They still have the ability to file for a Chapter 7 bankruptcy, the most simple form, the form that lets them go through the process more quickly. And that's by doing a very careful analysis of their income over 6 months prior to filing bankruptcy and looking at their expenses and seeing what the difference is. As you can tell from my explanation, knowing whether you can file for bankruptcy has become much more complicated and really requires good legal advice. Also, for many people, Chapter 7, the simplest form of bankruptcy, is not the right choice. They should consider relief under Chapter 13, sometimes called Wage Earners Plan. In Chapter 13, a debtor devotes anywhere from between 3 to 5 years of their disposable income, the difference between how much they make and how much they need to pay for their living expenses, to a plan to pay off their creditors. Some people who might be candidates for Chapter 13 are those who have a arrearage on their mortgage. They've missed a number of payments and they need to make them up, but they can't negotiate an arrangement with their creditor. Perhaps they have tax liabilities that they need to pay. They may have some assets for a business that they want to hang on to because those assets are the stuff that produces the income that allows them to continue to live in the manner to which they've become accustomed. All those people are candidates for Chapter 13, but they face an issue of being either too rich or too poor. If they have too much in the way of debt, either secured debt that has collateral or unsecured debt, they can't qualify for Chapter 13. And if they have more than approximately $360,000 in unsecured debt, things like credit cards, medical expenses, they can't qualify. But if they're below those levels, they can. And Chapter 13 can be a very, very important tool to gain the debt relief that the bankruptcy laws provide. Even if people are, you might say, too rich in that they have too much income, or too poor because they have too much debt, they can still, in some instances, qualify for Chapter 11 relief. Chapter 11 requires a reorganization plan. It is a very, very complex set of rules. They have to almost provide a prospectus, like a public offering of stock, where they describe what brought them into the bankruptcy, what their plan is for dealing with their debt, what income they're going to devote to pay off their creditors, and how they're going to handle different kinds of creditors. Bankruptcy can be a real thicket of a lot of different legal issues and problems. And one of the things that our firm brings to the table is experience in areas outside of bankruptcy. Many times for people who are looking to the bankruptcy code for relief, what prompts them to even be thinking about that is business issues or legal issues that are outside the realm of bankruptcy. Because our firm has experience in real estate, experience in contracts, experience in forming and organizing businesses and counseling businesses, we can bring that expertise to bear in helping clients navigate the bankruptcy code and the relief that's available. We also should state that we not only represent debtors in bankruptcy, but we do represent lenders and creditors in bankruptcy. In some respects, our experience in dealing with debtors allows us to do a good job in representing creditors because we kind of know some of the tricks that the debtors play. So we can help landlords who are looking at a tenant who's going into Chapter 11. We can help secured creditors get relief from the bankruptcy stay to proceed with their remedies. One of the advantages for a debtor is that when they file a bankruptcy petition, the automatic stay in bankruptcy goes into effect. It's like a big stop sign went up to all the creditors that said, stop all of your actions to collect the debt, stop your lawsuits, stop your judgments, stop your garnishments. From the creditor's side, the creditor can go into the bankruptcy court and say, Judge, we'd like that stop sign to come down because under the bankruptcy code, we're entitled to move forward with our remedies. And sometimes that could be a real battle. But we've had experience in representing clients on both sides of that battle, the debtors who are resisting stay relief and the creditors who are trying to get it. We have experience on both sides and can be of assistance to both debtors and creditors in dealing with how to get the best results they can under the law.